This is the last thing standing between you and a drink. And with that, it's my honor to be able to introduce the final Fireside chat with Kim Hart, who is the technology editor for Axios, who will be speaking with the Honorable Rob Rosenstein, who's Deputy Attorney General of the United States. Please join me in welcoming our next speakers.
All right, thank you everyone for sticking around. I wanted to preface our conversation with a slight disclaimer at the top. I know that there is a lot of interest in some news events of the day. However, this conversation is going to stay focused on the Department of Justice's approach to data and technology policy.
Is there something else going on?
There's nothing else more important than that. So Deputy Attorney General Rosenstein is going to stick to talking about those topics that he can discuss. So with that, I thought I'd end with an issue that everyone in this room has talked about a lot and is very familiar with on encryption. In a recent speech, you talked about your support for what you called responsible encryption and the ability of that couples secure encryption with the ability of government to access that information when needed. But you also don't want the government to micromanage the engineering of technologies. Can you maybe start us off by elaborating on how you see striking the balance of privacy and public safety?
Absolutely. I fully appreciate the perspective that so many privacy advocates have. And of course, from a law enforcement perspective as well, maintaining confidentiality of information, electronic information, is really important to us. The more we are able to secure information, the less likely we are to have fraud cases and other criminal referrals. So encryption is really critical to data security. But I also see the law enforcement.
So what would your advice be to the largest technology companies out there who say they're trying to protect their consumers' privacy and have a responsibility to do so, but also don't want to obstruct the law enforcement's efforts? They're in a tough spot. What do you think that they should do? What's your advice to them?
Well, what we're asking technology companies to do is to consider the balance of not only the need for encryption, which should be as secure as possible, but consistent with the need with a lawful court order to get into the devices. And so that's really all we're saying, is that there ought to be something else on the other side of the balance. And I fully appreciate the position that many technology companies are in. They're in a competitive business environment, and if the competition is for whose devices are more secure against court orders, then it's going to be very difficult for you to weigh the interest in law enforcement. But we think that the desire to promote good law enforcement, the desire to prevent your devices from being misused to promote criminal activity is a legitimate factor for companies to consider in engineering their devices. It wasn't that long ago that responsible access was engineered into operating systems for most devices. There are still some in which it is. We think that the movement toward law enforcement proof encryption is actually going to be harmful to the long-term interests of law enforcement and of the citizens.
I wanted to shift gears to one of the biggest buzzwords that we are talking about these days, cryptocurrencies. The largest illegal Bitcoin exchange, BTCE, was taken down by law enforcement last year, and after it received about, $4 billion worth of Bitcoin, most of it money laundered in some way from ransomware attacks or identity theft schemes. What is the biggest hurdle that law enforcement faces when it comes to the rise of cryptocurrencies?
Well, obviously, cryptocurrencies serve some legitimate objectives, but like most emerging technologies, criminals are often the first to jump on the bandwagon. So criminals see cryptocurrencies as an opportunity to move money without the ability to be detected, and therefore to protect proceeds of money laundering activities. And so criminals are essentially first adopters of these cryptocurrencies. And so while there may be legitimate uses, and there's certainly many people who engage in transactions with electronic currencies, the challenge that we face is that the ability to follow the money is really critical to prevent a lot of crime, crimes that are directed toward earning profits. And so we've seen in these cases, the one that you mentioned and others, that people are using these cryptocurrency technologies to commit crimes, to extort money through means which they believe will not be traceable, and then to launder that money so that they can shift it into accounts or into places that they can take advantage of it. And so that's the biggest challenge we face with cryptocurrency. If it's not going through legitimate financial institutions, we're going to have difficulty tracking it and identifying crimes. Also, it provides an opportunity for criminals to conceal income from taxation, which is, of course, another legitimate function of government. And so it does pose challenges for us that I think we're just really coming to terms with. This is only a problem that's emerged over the last few years in widespread use, and it's something that we're going to need to come to terms with.
How is the Justice Department trying to keep up with how fast this area is moving? And the amount of growth it's seen in the past year alone has been probably surprising to almost all of us.
Right. Well, one of the challenges is just keeping abreast of the technology. And so we do have experts in the FBI and in the Department of Justice in our criminal division, as well as points of contact within each of our 94 U.S. attorneys' offices, because we need people to keep up with the emerging technology. These are things that we didn't learn in law school, literally, because it didn't exist when many of us were in law school. So it really does require a focused effort by the Justice Department, the FBI, and other federal agencies to make sure that we're hiring people with the right expertise and that we're providing the appropriate training so that we're keeping up on emerging technologies and we have a sense of where the vulnerabilities are.
And I wanted to ask one more question before we open it up to some audience questions before we wrap up. Turning to data storage overseas and the Microsoft case in the Supreme Court, which is watched by pretty much every technology company that's doing business around the world. The case will determine basically what law enforcement needs to do to retrieve digital evidence on foreign servers. And there's a debate about whether this is best resolved in the courts or by Congress. How do you think we can finally get to a solution to this pretty complicated problem?
I think both might be ways to resolve it. As you know, we're challenging judicially the adverse decision out of the Second Circuit, I believe it was. And there are also proposals for legislative fixes. And this is an area actually where I believe to a large extent the interests of law enforcement and the technology sector are aligned. That is, our technology companies have an interest in knowing what the rules are, what they can and can't do with regard to foreign stored data, and when they're required to comply with subpoenas. So I think this is an area where, to the extent that there's a legislative solution, there really are opportunities for us to work together with the technology industry to make sure that we arrive at a solution that's going to be most efficient and will save everybody having to litigate this issue over and over again.
Senator Hatch has offered some legislation to this effect or in this realm. Do you support that? Are there legislative vehicles out there that you think would be effective solutions?
There are proposals that we're considering within the department. I'm not going to make any commitment to that one in particular, but I do think that legislation is often an effective way to resolve these issues when there are challenging technological developments that really weren't considered when earlier legislation was passed. That's one of the issues we face with regard to many of these judicial battles, is that we're applying statutes to novel technologies, and new legislation that accounts for emerging technologies makes it much easier for us all.
What would you say is the department's biggest challenge, and what is the biggest threat when it comes to protecting the digital economy?
It's the biggest threat, as you all recognize, is the threat of cyber hacking and intrusions. You all have to deal with that on a daily basis. As you know, our federal agencies are very much engaged, working on their own and working in coordination with industry to combat these threats. Some of them are from foreign state actors, espionage efforts. Some of them are commercial hacking efforts. Some of them are criminals who are out to extract ransom or extort corporations. But that's the biggest challenge we face, is that we need to continue to improve our cyber defenses so that we can help the private sector protect themselves against these intrusions. But this is an ongoing battle. I don't think we're ever going to reach a point where we can say we've solved it. there will always be criminals out there trying to find a way around our defenses. And that, I think, is the biggest challenge that we face in law enforcement. But we're working cooperatively with the private sector. Our goal is to make sure that we work with you to develop technologies that enable you to defend yourself, so you won't need to call on us after crimes have been committed and after you've suffered intrusions and data exfiltrations.
With that, I wanted to make sure that we got to some of the audience questions before, and remember that we're keeping the conversation germane to the topics at hand. Alex?
Sure.
I don't know if there's a...
No, I'm right here.
Oh, right over, oh, I'm sorry, go ahead.
Hi, Ed Black, CCIA. You articulated very well the balance and the encryption between security versus, if you will, privacy and security on the other side. And whether there is a solution that is mutually satisfying, I think is a very hard question to answer. But hypothetically, if there was a solution that law enforcement found pretty acceptable, we would have a further battle, I think, in the international context, because while we have a great deal of due process and procedural protections, the world does not in many regimes. And whatever U.S. standard would be developed would in fact be transferred globally and would have, presumably whatever it was the U.S. part of the protections is what would make it sellable. But that standard then becomes a de facto standard for the world, and there are many regimes that would be able to grossly misuse that.
I have two responses to that. The first is really to challenge the premise, because our major corporations are complying now with the laws of the countries where they operate. So there are companies already that are making accommodations because they have to do it in order to do business in countries that have different regulatory schemes than ours. But the second point I would make is that it's important to recognize this is an issue that actually frequently gets lost in the rhetorical battle over responsible encryption. I am not calling for the government to possess the keys, to use a colloquial description. I don't think the government should have the ability on its own to decrypt or break into encrypted devices. What we have in mind is a system in which the ability is retained by the manufacturers. So the keys are somewhere, but they're emphatically not with the government, so that we would require a court order or appropriate process, whether they're with a third party, whether they're with the provider. Those details I think need to be worked out. But the way that we envision this working is not that the government would have the key. The government would not have the ability to break into devices on its own.
Alex Howard from the Sunlight Foundation. Thank you for your anti-corruption work. We care about that a great deal, along with your commitment to being more open and transparent with the public. One concern we have seen consistently in the groups of peoples we work with, however, is public access to public information and the legitimate diagnosis of vulnerabilities and security issues in web browsers or devices or hardware. We've seen, unfortunately, prosecutors use the discretion they're granted under the Computer Fraud and Abuse Act in ways that concern us, particularly with respect to chilling the act of so-called white hats, people who are trying to diagnose and find problems. The Department of Defense has had a very successful bug bounty that's put out where they're encouraging the public to help them find issues. Would you support reforms to the Computer Fraud and Abuse Act or offer guidance to the nation and to law enforcement officials? They make it clear that accessing public information and then telling public officials that it's there is not a crime, and moreover that if journalists document those issues and link to them, that they also should not be prosecuted for effectively telling the public servants that they have a problem they should fix.
Alex, that sounds very reasonable. I fear that it's a loaded question, but so I don't know what the hidden meaning is, but generally I would say yes, I think I have in fact talked about that DoD model as being an effective model of encouraging people to come forward voluntarily and identify weaknesses. That's how we find them. We want to find them before we're victimized. And so generally, yes, I gather you must have in mind cases where you think somebody really was a white hat hacker who was prosecuted. So I'd have to know the facts of those cases. But as a general matter, I would say yes, we do. I think the DoD model is effective of encouraging people to come forward in a constructive way when they identify a flaw and not try to abuse or misuse it in order to commit intrusions or exfiltrations.
Hi, Amy Stepanovich from Axios Now. I actually wanted to ask the flip side of Ed's question, which is not only will other countries potentially abuse any capability the U.S. asks for, but other countries are right now using the conversation that's happening in the U.S. and that has been going on for the last few years to justify implementing measures into their own laws, whether it's Brazil, Australia, the UK, China, that would limit the amount of security that companies can offer their customers. And in my mind, if there's anything worse than limiting the way users can be secure in one way, it's limiting it in 5 different ways in 5 different countries. Does the U.S. owe some sort of international obligation to the idea that hacking and corporate espionage and security is the biggest challenge that you're saying faces the digital economy, to try to make security better and not make it worse globally?
Yes. Yeah, I'm not sure exactly what you're getting at, but yes, and that's why we talk about it in terms of a balance. Absolutely, we are in favor of encryption, and there are experts who argue about whether or not what I have in mind is feasible. And I don't purport to be an engineer, but there are experts who say, yes, it's feasible, that we could and have, in fact, developed systems. There's a Symphony system, for example, used by some financial institutions in New York. We do have systems where we retain a high degree of confidence in the security of the system, but nonetheless, we preserve lawful access for regulatory or law enforcement purposes where there's a legitimate need.
We have time for 2 more questions. Yes, right over here.
Hi, David Green with NBC Universal. Mr. Deputy Attorney General, I wonder if you would speak about the priority of your department with the issue of piracy, content theft, and whether that's still an important issue for the Department of Justice.
That is still an important issue, Mr. Green, as it was when you were there 25 years ago. One of my early colleagues at the Department of Justice, absolutely. We haven't talked today about intellectual property, but that is one of our top priorities. In fact, we recently established intellectual property coordinators around the world. We announced, I think, 5 IP coordinators that we've set up. We've actually detailed department attorneys to be stationed in foreign locations to coordinate efforts in those areas, because we recognize a lot of this threat comes from abroad. And intellectual property is critical to the success of American industry. Entrepreneurs deserve to know that we're going to do what we can to protect their intellectual property interests. And so, yes, we are very concerned about piracy, and our department's criminal division does have experts who focus on IP, and that continues to be a very high priority for us.
One more?
Hi, Kathy Gellis. I'm an attorney in private practice. My question, going back to the encryption keys that you think would be, I guess, retained by companies. How is a company to respond if they suffer a data breach and the only thing compromised is the key that they've been holding on to?
Right. Well, obviously, your goal would be to prevent that. And as I explained to you, I am not an engineer. And so, certainly I would acknowledge that having a key creates more risk than having no key. The question is, can you can you engineer a system that is sufficiently secure, that there is adequate assurance that those keys are not going to be wrongfully accessed, or that if they were, if somehow the provider or the third-party custodian lost control of them, that we would have appropriate notice so we could prevent any improper use of them. So that's a challenge that I think is appropriate for engineers. I feel relatively confident, based on experts that we've consulted with, that it is feasible. And there are, in fact, systems out there that seem to be reasonably secure, but nonetheless do provide the opportunity for responsible access with appropriate judicial supervision.
Thank you. I think we're out of time, but thank you very much for joining us today. And for everyone in the room, I'm told to let you know drinks will be in the next room.
I'm sorry to miss that part. Have a good evening. Thank you. Thank you, Tim. I appreciate it. Thank you.